Hi, I'm Ed Villanueva, head of EMSI Consulting. EMSI is a management consulting firm that specializes in the field of labor relations, and we've been representing companies for well over 30 years. Today, our presentation is called Being Union Free, a basic look at several lawful ways to decertify a labor union. Yes, in fact, there are various options to consider if your goal is to ultimately be a union-free company. Before exploring how to get rid of a union, the question of how the union got into your company in the first place is one that needs to be researched and evaluated. Typically, it happens when the employees, at least those that worked for your company at that time, voted them in via an NLRB, National Labor Relations Board, election. In some cases, the company voluntarily recognizes the union without any challenge. Or, in more rare circumstances, it's mandated on the company. We see this often in cases where business contracts with municipalities or certain construction projects demand that the contractor be a unionized company. The government can sometimes impose the union on a company if the company has violated the labor laws to the degree that the NLRB feels that it cannot conduct a fair and even-handed election. So regardless of how the union got in, we know that after the union had their victory, they became the certified bargaining agent and the representative of all of the employees in that particular unit. Mind you, that's not the employees who wanted the union, but all of the employees. And this is a key factor as you look to the subject of decertification. Then the company had to recognize, negotiate, and deal with them on all matters involving wages, hours, and working conditions, as you probably well know. Typically, near the end of the contract, both parties will sit down to attempt to renegotiate a new contract, and so on and so on. That's the status quo. Unless you take some lawful and timely steps to challenge the union's representation status. So when and how can a union be decertified? According to the law, a new petition for an election can be filed at a specific window period as the end of the contract approaches. The window is 60 to 90 days before the end of the current contract. So take a look at yours, and that will be very determinative. If the contract is for more than 3 years, the petition can be filed at any point after the 3-year period. There are basically 3 ways to ultimately be rid of a union. One is when the employees get signatures from at least 30% of their coworkers, and they go on to file an RD petition with the NLRB. 2 is when the company files an RM petition calling for an election. That's right, the company can take the initiative and request that the NLRB conduct an election to determine whether or not the union stays or goes. 3, enough evidence exists for the employer to withdraw recognition of the union as the bargaining agent of the employees. We're going to talk about all 3 of these in more detail coming up. Which is the best way? Whichever one gets rid of the union at your workplace is really the answer. But there are pros and cons of each option. In the case of an employee-driven, an RD petition, the pros are that the labor board tends to look at this option as the most favorable one because it is the employees themselves who are asking for an election. On the other hand, employees may lack the courage and the drive to kickstart a signature gathering process and then go on to follow the NLRB procedures, which can sometimes be very complicated. Option 2 is when you, the company, can file an RM petition. In this case, the upside is that the process does not rely on the employees having the initiative to confront the union, get signatures, and file a petition for an election. You, the employer, take the appropriate legal steps, relying on proven case laws that we have used successfully. The downside is that the NLRB will look closely at the evidence presented in support of the petition and look for any management taint before it will move to conduct an election. The RM petition. It's a seldom used approach, but it's a proven EMSI secret weapon that we have found to be successful with many clients. So let's talk briefly about the third option, withdrawal of recognition. In this case, the pros are that no election is conducted, so there's nothing to win or lose by way of the employee ballot box. However, the downside is that the union is going to fight very hard against this effort, and it will lead to significantly higher legal fees. Also, the NLRB is going to require a significant higher level of proof in order to grant this employer option. But it's there, and it certainly is a lawful possibility. So, is it doable? Absolutely. All three are legitimate legal options under the National Labor Relations Act, that is, federal labor law. So what's the first step? Well, contact us. EMSI will conduct a quick review of your particular situation with you. The initial review will reveal some key factors determining the probability of a positive outcome. The key is the date of the expiration of your contract, so as to not miss the window period. So, when is the right time to begin the process? How about now? Ideally, you need to start several months before the end of the contract in order to do the necessary work that is required before the 30-day window period. So here are some final thoughts for now. Hopefully, we will have a chance to review this further with you. First, decertification of a union is lawful and it's achievable. There are many misconceptions and bad information circulating about what you can and can't do or say or not say to move the process along. I find that many companies feel that or have been told that they can't talk to their employees about the subject of decertification. That's simply not true. You can talk to them. It's just a question of what you say, how you say it, even when you say it. But you do have a right to discuss this subject with them. And lastly, there's absolutely nothing unlawful or unethical about reviewing your options and your rights and going ahead and using them. So contact us for a free initial discussion and an evaluation of your situation. The direct contact information is on your screen right now, including my direct line and direct email. Thank you for reviewing this presentation. We certainly look forward to helping you achieve your goals.